This is Mark White. I'm an attorney based in Berkeley, California. One of the topics that we look at in California is managing seismic risk. That is the risk that is associated with earthquakes, and in particular with institutional owners and then sometimes smaller owners. The issue arises how to manage the risk that is inherent in potential seismic activity. We recently, that is last Sunday on August 24, had an earthquake based in Napa, California. Medium-sized earthquake, moment magnitude 6, which caused damage in Napa, caused no damage of any significance in San Francisco. This presentation is to talk about the lessons that can be learned from the Napa earthquake, as well as other earthquakes that on the Pacific Rim that preceded it, and in particular some practical guidelines can be gleaned from these events for managing seismic risk in the legal arena. So the title of the paper that we put together is Managing Seismic Risk in the Legal Arena, Lessons Learned from the August 24, 2014 South Napa Earthquake and Other Earthquakes on the Pacific Rim. This is done with the assistance of Dr. John Osteros of the Exponent Inc. firm based in Menlo Park, California. So our first slide after the introduction is what's known as a USGS, that is the United States Geological Survey shake map. It shows where the earthquake occurred in Napa on the 24th of August. It shows the relative significance or magnitude of the earthquake. The redder and yellower the color, the greater the energy release. As it turns out, there's a nonprofit organization called the Earthquake Engineering Research Institute that did a preliminary report immediately after the earthquake, that is 2 days ago, and determined that the peak ground acceleration in downtown Napa, which is a small city, was 0.6 Gs, that is 60% of gravity. That was the peak ground acceleration. Next slide shows what 6/10 of gravity will do to a retrofitted structure. That is a partial collapse of the corner of this building. And again, the distance between the epicenter and this building was approximately 7 miles. And that's the kind of damage you'd expect on a reinforced building that had a retrofit that was unable to develop the capacity to meet the demands of this particular earthquake, where peak ground acceleration again was probably on the order of 6/10 of 1 gravity. Next slide is the same building taken from another angle. You can see relatively new roofing material and window materials, and you can see the shearing off of the part of the roof assembly, making the building probably red taggable and uninhabitable at this point. So when we have this kind of performance in California and on the Pacific Rim, a question arises, and I'm going to call it a trick question because it's one that will catch some people by surprise when we discuss the answer. And the question is, as a matter of law, is a building owner immune from legal liability if it chooses to design, build, or operate a structure in accordance with minimum building code standards? That is, if the owner says to the design team and the contractor, build it to minimum code standards, is the owner exempt from liability to third parties that might be injured by the performance of the building in an earthquake? The answer is no. In a published court opinion that came down in 2010, we call it the Myrick opinion, the trial judge, the jury, and the Court of Appeal all found that a building owner can have legal liability even if its management and use of a structure is in accordance with the minimum standards of local ordinances and building codes. So in that case, the Myrick case, there was a 6.5 magnitude earthquake less than 25 miles away. This building, called the Acorn, had a roof collapse, and approximately in the area of the vehicle that is shown below, 2 people were killed, and they brought claims against the owner. Jury found that the owner had not behaved reasonably, even though the building was in compliance with local code requirements. Here's another shot at the same building taken from ground level, and it illustrates the danger that can be created by a building that does not perform well in a foreseeable earthquake. Earlier there was a building that was completed about 30 days before an earthquake, and this is the base of the building, a two-story, actually two-tower structure, each tower about 10 stories, with the ground floor and the second floor were open for views of the ocean, Pacific Ocean. When the earthquake hit, this is what the building looked like. The open second story disappeared because it was a soft story. There was a partial collapse of the tower on the beachside. The second tower did not collapse and held up the beachside tower. So if we go back, you can see the open area that, as a result of the 7-point earthquake less than 50 miles away, caused the collapse of the second story. As a result of this, the owner had to prosecute claims against the design team, and the contractor had to settle up claims with the injured parties, and the litigation took approximately 6 years to resolve. The parties finally settled. So we have a general rule that can be gleaned from these and other cases on the West Coast. The general rule is that statutory compliance is not a complete defense in a lawsuit based upon poor performance of a structure during an earthquake. A statute, ordinance, or regulation ordinarily defines a minimum standard of conduct, and mere adherence to that minimum standard does not preclude a finding that a reasonable person would have taken additional precautions under the circumstances. So to recap what I just said, the general rule in brief is that adherence to a local building code or local ordinance does not assure the owner that it won't be held liable if its building performs poorly in an earthquake. A jury is going to be allowed to evaluate whether a reasonable person would have taken additional steps above and beyond what the code required to assure that the building would perform adequately during an earthquake. So the issue then is, for the owner, what level of seismic performance should the owner choose when directing its structural engineer to develop the design for, first, a new building, or second, when retrofitting an old building? And how does that choice help demonstrate that owner took reasonable steps under the circumstances to protect others? That's the issue. One of the available options that owners can choose is that it can direct its structural consultant to develop a design that creates a chance of 6% or less that the structure will collapse in a severe earthquake. This is a development that's occurred probably in the last 20 years or so, in tandem with the Uniform Building Code and later the International Building Code that is used in the Pacific Rim in the American jurisdictions. You can see in this excerpt from one of the reference materials that's incorporated into the building codes that if the design professional is directed to design in adherence to risk category 3, there's a 6% chance that a maximum considered earthquake could cause a collapse. If you go with the higher risk category, such as those used for hospitals and police stations, the risk of collapse drops to 3%. If you go with a lower risk level, that is 2, there's a higher chance of collapse, 10% of collapse in a large earthquake, a severe earthquake. So as we think through these principles and we try to manage the seismic risk in the legal arena for clients, often owners, there are 4 considerations. One is that one element of risk that has to be considered is the investment in the structure itself can be at risk as a result of poor performance in an earthquake. So the owner needs to consider, as it spends resources on developing a design either for the new structure or for retrofit, how much capacity it wants to build in, how much it wants to spend to reduce the likelihood of collapse because, among other things, the investment in the structure or the facility is at risk. So the second consideration is that the commercial relationships that the owner or the landlord has with tenants or with other entities that rely on the physical presence of the facility, those relationships are at risk if the building performs poorly in an earthquake as well. That's something that the owner needs to consider. We don't want to have a situation where the business that is associated with the facility is compromised or maybe rendered defunct if it cannot maintain relationships, commercial relationships with customers and tenants. The third consideration is that Poor performance in an earthquake can trigger legal claims by contract partners, visitors, and neighbors. That is, third parties who are visiting, for instance, a facility that are injured, that can lead to earthquake, or that can lead to personal injury claims or wrongful death claims, as in the Myrick case, where the death of 2 women caused the owner to have to pay $2 million. Finally, there are short-term costs associated with increasing the capacity of the structure and improving its overall seismic capacity, which should lead to improved seismic performance. There should be an analysis of whether those short-term costs yield sufficient long-term benefits. This is an area that research has been undertaken the last few years, particularly in those risk categories that I identified earlier, and there's some indication that the increase in cost to go from, for instance, Category 2 to Category 3 is on the order of 3 to 5% of the total project costs. So, as you can see in this next slide, we want to see the industry as a whole, and indeed the academic parts of the structural engineering community, start to do more research on what the average expected additional costs will be incurred to increase capacity from, for instance, Category 2 to Category 3. Right now it looks like it's going to be 3 to 5%. So at this conference, we've been considering what the added value of these recommendations are for disaster risk reduction. So in conclusion, we should look at the added value for the post-2015 framework for disaster risk reduction, which is the principal theme of the conference. The first consideration would be that by requiring their structural consultants to identify the costs and benefits of adhering to elevated performance standards, owners of new and retrofitted structures can choose to improve seismic resilience, increase life safety, and reduce property damage in severe earthquakes. Second, those choices will be enhanced by additional research on, first, the structural performance in scale model laboratory testing at universities such as the University of California, and second, additional materials costs for elevated seismic performance. Thank you very much.